So, yes, good. Then, yeah, I think we can start. This is the first presentation of the first Cyber Economic Forum here in the beautiful Switzerland 2020. And I want to talk about not so much net neutrality, we might come to that at the end of this presentation. But the first issue that I would like to bring to your attention is really the one that's also at the forefront of my attention, that I find really the most relevant and interesting discussion that we'll have in Europe for the next 3 to 5 years. And that is the so-called Digital Service Act or platform regulation. In essence, it's really the question of how we want to govern and regulate the internet. So in a way similar to net neutrality, but not so much on the infrastructure level. It's more about the big online platforms. It's about the Googles, the Amazons, the Facebooks of the world. So that you know who is speaking here, my name is Lohninger and I'm coming from epicenter.works. I'm executive director of that Austrian-based NGO. We work on all things digital rights. We were founded as an anti-surveillance NGO, but also earned our spores in net neutrality. We work a lot on copyright these days. Thank you. That clap means a lot. And yeah, so that's my institutional foundation, that's my day job. And I'm also on the board of EDRI, European Digital Rights. If you want to succeed in digital policy, you have to go to Brussels. That's where the rules are made for 500 million people. And EDRI is the umbrella organization of 42 NGOs, including big names like EFF, Privacy International, or the Chaos Computer Club. It was founded in 2003 as just a bunch of volunteers that wanted to have a common voice in Brussels. These days, it's the biggest lobby organization for civil liberties in Brussels, with a staff of 15 people and very well known. As we are in Switzerland right now, and there are also some international people here, I will really want to start with the basics. Why should you even care about the European Union? First of all, there is this great document, the Charter for Fundamental Rights. Europe, maybe more than other regions in the world, is aware of its historical responsibility and of the value of fundamental rights. And those are not just citizen rights, they apply to every human being, no matter their citizenship. And that is a very important pillar also for the digital rights work that we do. Secondly, what we do here in Europe can really have worldwide repercussions. The General Data Protection Regulation, the GDPR, was really vital in the time of Snowden. If you imagine a world after 2013 without that law, maybe the concept of privacy or data protection would have been gone, or at least would look very differently. And this European law that protects 500 million people also had repercussions worldwide. No matter if you look to India, to Kenya, or to California, most of these laws are modeled after the GDPR. So that's a positive example of Europe, but there's also a negative example. The Copyright Directive and the upload filters enshrined in there are a very dangerous precedent that could also have repercussions in the rest of the world with upload filters, which are a very dangerous type of technology for our freedom of speech, also being found on other platforms and regulating our speech. And in a way, copyright and upload filters is linked to what I'm going to talk about. Platform regulation is really about that concept of intermediary liability. An intermediary, you could think of a newspaper. Those are mediators. If you are the publisher of a newspaper, you are liable for whatever your journalists are writing and what you are putting into the paper. We've accepted that. We came up with a media law. It took us decades to come there, but these are established principles. And when the internet came along in the 90s, people tried to apply those principles to the internet. And suddenly you had raids to ISPs in Italy, in Germany, in Austria, sometimes even criminal prosecutions to the CEO of ISPs. So they thought an ISP has to be held liable for every information that flows over its pipes or that's hosted on their servers. That, of course, was not the way to go. And that's why the EU adopted the e-commerce directive. That's a safe harbor so that you as an intermediary, as a hoster, as an ISP, are not directly liable for what people put on their servers or in their network. And in essence, this is like what you can boil the law down to. You're not liable if you don't have actual knowledge. If somebody tells you you have something illegal on your servers, you have to act right away. That's the essence of the notice and takedown system that we have all around the world. This is not EU specific. In the US, it's Section 230 of the Communications Decency Act, and you have similar laws all around the world.
Can I add something? 230 is absolute immunity, not notice and takedown.
Yeah, of course, but it's also, that is 14, and I'm not talking about 11 and 12. You're right.
No,
Shit, there's a US lawyer in the room.
No, because I think Americans, companies are very, I feel like they're more protected than the Europeans. Is that wrong?
They are, in a way, because I actually deleted that slide. You have that Good Samaritan principle in China law. You have the shield and the sword. In Europe, we only have the shield. So if you use the sword too much, you actually can become liable. That would never happen in the US.
Right.
So fast forward, that's 90s. Everything was fine back then. We had a decentralized internet, and everybody still ran their own infrastructure and stuff like that. The internet has evolved. The problems that we see in the current internet ecosystem, I think everybody is aware when we talk about hate speech, when we talk about the enforcement about illegal content online. We have all of these big platforms, and if you look at the numbers, you see that there are millions and billions of posts and videos uploaded every day. And that idea that you would have to pre-screen them before they appear online, of course, is totally ridiculous. So there is a lot of content moderation already happening, but the documents on which this content moderation is actually based on are not our laws. They are mostly terms of services. So they are the Facebook community standards or other documents that might change 3 times a week, and there are also secret documents that really are applied by the content moderators, which often sit somewhere in low-wage countries like the Philippines, and they have a few seconds to actually make a decision about that content. And so it's a really problematic system, which has become more center stage in recent years. Most recently in TikTok, to have a Chinese example in here as well, the rules were leaked that governed the content moderation practices. And in there you had some really nasty stuff that, for example, people with disabilities, with Down syndrome in particular, would have been curved in the reach that their posts could have. Also people that are not slim, have a normal or bigger body size, would have been curved in their reach. So their videos would not get a critical amount of attention. And that's still written rules that are applied by humans. If you look closer, AI is now the way to go, how content moderation is actually happening. If you listen to the testimony of Mark Zuckerberg in Congress, then he was actually always answering with AI whenever he came to the tricky questions about content moderation and freedom of speech. And of course, all the programmers in the room might agree that a computer is really bad at contextualizing content, as recognizing if something is meant as a joke, which, for example, is a parody exception in copyright. All of these safeguards for our freedom of speech might get lost if we hand over these important decisions to computer programs. The EU had previous legislative files and other dossiers on this issue. Basically, it was always like that. The EU fights for a clean internet and tries to tackle online content. So we had several proposals on the EU level, starting with the copyright directive that was already adopted last year, terrorist content regulation, again, upload filters for extremist content, and what terrorism is defined by the member states, which means in Spain it also includes Catalan content because of the independence movement there. So there's a range of legislative files and also codes of practice and code of conducts. These are very nasty things. These are not laws. This is the European Commission sitting down with the big corporations and saying to them, we would really like you to do that. So do you want us to regulate you or do you just behave? There is also a range of national laws that have been adopted, which also puts a lot of pressure on the European level because they want to still be on top of things. They want to make the rules and not have member states really setting a too strong precedence here. And in essence, we have one drastic shift that comes into play here. Our governments are obliged to protect our fundamental rights. But more and more we see that the actual decision about content moderation is outsourced to private entities. And these private corporations, of course, are not bound to protect our fundamental rights. So the playbook of all these laws, also the NetzDG in Germany, is quite simple. You are outsourcing what you don't want to see online to the terms of services, which tackles both illegal and legal but harmful content. And then at best you have quick or automatic takedowns. And only if you fail to remove these types of contents, you have a penalty. So there's also a very strong incentive for overblocking And the risk for a platform is always deleting is safe, or if you actually assess it, you might run into problems. And of course, the assessment itself is costly. To increase complexity further, this is not just about content moderation. This also includes, for example, counterfeit products that are sold on eBay. We have legislation from European High Courts in the L'Oreal eBay case that comes into play. And then we have a recent judgment that Uber actually is a taxi company and not protected under current safe harbor exceptions. Finally, this is not just a European debate. In the US, we already had a law that was adopted bipartisanly with the Stop Enabling Sex Trafficking Act that already limited the intermediary liability protections. And it's not just the Western world, also in India, there is a law. I spoke with a colleague this week that is working in India, and she said that the law is actually quite bad. And in total, many countries are looking to this content moderation debates. The NetzDG law from Germany, for example, was already copied by 17 other countries, Russia being the first of them. So these regimes, you could say, are also quite keen to use these sticks against big internet corporations for their ends. So what's going to happen in Europe? We've been fighting back against the reform of the e-commerce directive to protect the existing intermediary liability rules for 2 decades. But now that fight is gone. With the now existing Commission of Ursula von der Leyen and her work program, we know that under the term Digital Service Act, there will be reform of the existing liability rules. And so far, there's still a lot of fog around it. We actually don't know what concretely we'll see in that proposal. But ideas on the table based on leaks from the Commission give us some idea. Of course, they will have to update the definitions. Those are from the early 2000s. They have to be broadened to include the services that we know today. One thing that we have to fight for is the current ban on a general monitoring obligation. So the governments cannot oblige an internet corporation to actually screen all of the content that's uploaded. And this current ban on general monitoring is already in contradiction with the copyright directive. So they have something to solve here, and privacy is a core issue that we have to protect and keep an eye on in this debate as well. Of course, content moderation will be center stage, and there are many proposals out there. Then, very interestingly from our side, are rules on online advertisement. Actually, the way money is made on the internet, with personalized or targeted advertisements, is the cause of many of the problems that we experience today. So instead of regulating the symptoms, we should really go after the cause and also, at the minimum, create more transparency about targeted advertisements. One very dear to my heart issue is interoperability. Interoperability means that a service needs to be accessible, or at least offer some form of API interface to their competitors. Interoperability really would allow us to bring the internet a little bit closer to the decentralized vision that we originally had, of an internet where you don't have to be on Facebook in order to communicate with your friends, or not on WhatsApp if you want to get the updates from the other parents from your children's school. And so forcing, for example, WhatsApp to be interoperable with Threema, with Signal, with Wire, is something that you could do with this reform. And there are many privacy and security questions that we need to answer if we open these things up, but we think they're solvable. And it's one of the good things that could come out of this. Cooperation with public authorities, you can think of Airbnb, for example. In many cities you have taxation for tourism, and if you have a private hosting service, you're renting out a huge building like this, it could be that the government is actually losing a lot of money in taxation. So forcing these online platforms to also give that data to public authorities is a legitimate goal that they also try to bring to the table. And lastly, of course, all of the enforcement might be done with a new platform regulator, and that will most likely be an agency on EU level, although the debates around it are also if we couldn't just recycle existing agencies. So all of these reasons are why the Digital Service Act is often dubbed the constitution of the internet, because it's such a vital rule book that could apply to so many of our daily online interactions, and that term constitution of the internet actually comes from somebody from the Commission. So that's also the way the institutions are already thinking about this reform. And if you don't know already why this is important, think about the stakeholders that will fight around this fight. So of course, we have GAFA. All of the US Silicon Valley companies will have a vital interest in this reform. All of the European internet industries will have to fight for their economic interests in this reform. All the telcos, CDM providers, naturally. So basically all of the stakeholders from the privacy debate and then all of the stakeholders from the copyright debate. All the classical media, Hollywood, entertainment industry, that's just one side of the argument. And then the providers of upload filters, like Facebook, Google, or Audible Magic. And don't forget all of the brick and mortar stores, the hotel operators, the taxi drivers, they might also have a vital economic interest in this reform. And then it's us, the digital rights community, that for this fight really tries to be early. There are several national and European organizations really intensely working on this reform. And then you might also see actors like Amnesty, human rights NGOs, participating in that debate. And lastly, but most importantly, I would say, also all of the marginalized groups. So all of the anti-racism NGOs, feminism NGOs, basically all of these disputes that we also have about the way Facebook is currently regulating our speech might be brought to the table here. So I often call it the mother of all digital rights debates, because in a way it's the end fight that could really see all of the actors that we had fights with over the past 2 decades culminating on one file. And in my tenure in digital rights, I've never seen a file with such a broad range of possible outcomes, both good and bad. So, yeah. What's next? This thing is still early stages, so right now we are on a working level. There will be a consultation from the Commission. You could expect it in the next months, at least I would expect it no later than the summer. A proposal at the earliest would be expected late 2020, and then of course it needs to go through the Parliament and through the Council, and only if that's done we enter trilogue and ultimately adoption. And we don't know how the incoming commission, like Berry Pétron, the French commissioner, will actually, if we'll fast track this and give it enough time to have a factual debate, or if they stall it for 3 years and then make everybody hurry to get it over the finish line before the election. We try to be early for sure, so on platformregulation.eu we've tried to publish our wish list for this reform in the format of an RFC, a request for comments. So that's all the things that we would like to see and also how we would solve the real problems. There are problems with the poor quality of existing content moderation. There are problems with competition and interoperability. Let's bring concrete solutions as a community. And right now it's still early enough to really have a factual debate with the Commission and find some of these proposals maybe also in the adopted legislation. That's it for platform regulation. I still have 10 minutes, so maybe now we still could talk about net neutrality. If you want.
I'm here for that, yeah.
So yeah, net neutrality in Europe. Why aren't we done with this? I had a talk with Tim before, and I don't know if I'm just speaking for myself or both of us, but it's gotten boring in a way. It's no longer the center issue of many debates, but if we lose net neutrality, we might run into many more problems. Because the centralization that we see right now on the online platform sphere, if that vertically integrates, like it is already happening in the global south with Facebook's free basic service, then we really lost the game. So keeping net neutrality is essential to even have the possibility to fight these other fights. And of course, this whole notion of net neutrality can be understood as the difference between the internet and television or telephony networks. And in essence, net neutrality is always discrimination protection, both on a technical level against throttling or privatization, or economically against making certain data more or less expensive. Ultimately, net neutrality protects people like this one, Mark Zuckerberg in his storm. He paid like $80 for the first server for Facebook. And wouldn't you say like he's an evil dude? Yes, that's also why he is against net neutrality these days. Like Netflix, they also were in favor of net neutrality, but then when it was clear that Trump might abolish it, the CEO of Netflix told the shareholders, don't worry, we are now big enough to survive without it. So net neutrality is always protecting the small actors. And the situation in Europe is such that we had to fight for 2.5 years with 6 versions of the Safety Internet campaign and several demonstrations to get this law that's still in effect. It's a regulation that applies in all of the EU that protects our rights when we access the internet, us meaning both consumers as well as content and service providers. It doesn't make any differentiation there and has non-discrimination rules for the telcos. The whole issue was summarized by us in this report from January last year, and I'm not going to go much into the details, you can find it online. It's only just one chapter and one thing that I want to show, the zero rating evaluation that we did. That was a lot of work. We actually had to survey 225 mobile operators to get all of the zero rating offers that exist in Europe, and we have that problem in all but 2 EU countries. So only in Finland and Bulgaria, you will not find a zero rating product. And if we then also look on the application side, who is profiting from this practice of exempting certain applications from your monthly data cap? It's mostly US corporation. The number 1 and number 2 are both owned by Facebook, and only 3 out of 20 are actually from the EU. The rest is mostly US-based services with 1 Israeli service in between. That's the background for the ongoing reform, with which I want to conclude. So right now there is a net neutrality reform happening in Europe. We are already quite late in the game, so there was a scope and there were several stakeholder meetings where we participated, and the draft was released October, November, consulted, and many organizations participated, voiced their opinion, and in June we'll have the new rules. And why is that at all important? Because of 5G. The next mobile network generation is really just a generation. It's often portrayed as the revolution of our internet communication. It is really just an evolution. Like previous network technologies, it will lead to faster internet speeds and have other technologically interesting improvements, but fundamentally it's still the internet. The question is more about the business models that will see how this internet is sold to us. And that's exactly why, in a global perspective, putting that business question together is putting Europe in the center stage. In the US, we no longer have net neutrality. Their 5G rollout is underway. Canada, last time I spoke with the Canadian regulator, they said they're not going to touch it for the foreseeable future. That was at the previous IGF. And so the good net neutrality laws in Canada won't be applied to 5G yet. Similarly, in India, they are taking a backseat approach, still busy with 4G. And in South Korea, they have a really weird net neutrality law to begin with. And they are also thinking about sandboxing it. So just saying, you use this new technology, you don't have to oblige by our laws. And the South Korean approach should probably not be followed by other regions. And that only leaves Europe, trying to square these two things. But what you have to understand is that the standard itself is global, of course. That's a technological standard that's applied by Huawei, by Ericsson, by Alcatel, and those are the same devices everywhere. The big question is only how is it marketed to us? And the one thing why we should care is a thing called network slices. It's an aspect to 5G that, as the name is saying, really slices the internet into individual layers. So you could have a slice that's very high bandwidth, or very low latency, or very low energy consumption. And the big question then is, who decides which application gets which slice? And I skipped the details here, but the direction that we successfully could enshrine here in Europe is that it is the user. You buy a 5G connection, you have more than one internet type, you have a low energy, you have a high bandwidth slice, and it should be you as the user who makes that distinction, which application gets which slice. And I hope that this model is also followed by the rest of the world. And lastly, people told me I should say something funny too, so I thought we're gonna do something funny out of history. How do we campaigns in Europe? When you want to lobby these people, the 751 MEPs in the European Parliament, one just joined us. Hi, Karen.
Sorry for being late.
And so it's actually really hard if you don't have friendly MEPs like Karen to get in contact with them. Most of these people don't care about our issues yet, so we really have to be creative to get their attention. And one thing that we did in the original Safety Internet campaign is sending faxes. Because the fun thing is, the faxes in the European Parliament are actually delivered by, it's one of these multifunctional devices that also acts as a printer, but only has one network cable. And so we created a website where people could send their message why they wanted the Safety Internet, and it would really be printed out in the offices of each and every MEP. So you have to choose which one you want to send to, and it's only one fax per one click, but you can click many times. And so we killed a lot of trees with that, I'm sorry for that, but it was very effective. So effective that we could win the first reading fight in 2014 and get really good net neutrality in the parliament. But since, of course, now faxes are delivered in Outlook. That no longer works. You could send emails, but we all know there are spam filters, forget it. You could, of course, tweet at politicians, but as we've seen with the copyright fight, then creative conservative politicians say, oh, these are all bots. These are not real voters. These are not people. They are all bots, or Google bots even. So even social media communication gets increasingly less effective. And in the recent copyright fight, in 2019, when it was really close to the finish line, we became creative. Because there is still one way that is not blocked or filtered to get the attention of a member of the European Parliament. And that's phone calls. But if you look at the nerds around you, like one of the things that nerds really don't like to do is speaking to people, and then speaking to people on the phone that they don't know. It's really hard. It's really, really hard. So we thought about that. How could we still make that work? With technology, of course. And so what we did, we created that website, pledge2019.eu. Pledge meaning a two-sided promise. A promise of the voters, I will only vote to you in the upcoming election if you don't vote for upload filters. And the pledge of this, as a politician, I'm not going to vote for upload filters. How would you enforce that pledge? By making these calls. How do you get people to call? It's only a conversion rate of below 1% that we had with that website. And we had tweets from Snowden, banners on Reddit, on Pornhub. We really had a lot of traffic. But the 1% conversion rate, we offered call subscriptions. Daily or weekly call reminders. And by that, you could actually be very efficient with your calls. We had a whole algorithm behind it to actually choose the most effective MEP for you to call, that's most swayable. And ultimately, that was very successful to the point that many assistants complained to me, why do you send all of these calls, that's so worrisome. And then we had to explain, every second you have to spend on the phone is a second that one of your voters is committing and donating for a political issue. And then they were silent. These tools are very well known in the UK and also in the US. For Europe, that was a novelty. And the tool that we programmed here was really a one-off. It was also not good code. We did this in a very hastily programming sprint, and it's not reusable, sadly. But I think the methodology behind it should be taken up for maybe the Digital Service Act. Yeah, I told you about the Snowden thing. When you campaign in Europe, you have to think that you need all of these partners in the other countries. You need people on the ground that speak the language, that have a media network, have a community. Only then you can win. And so we had 17 NGOs of 13 countries, translated that whole website into 12 languages, all by volunteers. We had no budget at all. And yeah, it was also quite data-driven because we really had a lot of insights how each and every MEP has already voted on copyright, and so we could actually see which are the most favorable countries, how many maps do they have, and where should we focus our attention. And yeah, at the end, like all of that was done without any funding from the outside. We just did it with the donations that we receive, also because it was so fast that we did not even have the time to write the grant. That's it. Here you can follow us on newsletter and on Twitter, both us as epicenter.works, my organization, and AdReader Network. And yeah, that's it. Thank you. You want to do questions? Or you want to just hand over? Other questions? Oh, yeah.
How many phone lines or phone numbers did you use for the calling in? Because I thought they're just gonna block a whole phone number blocks that you can't reach them. How
They do
many
that,
times
but
have you lost?
the thing is that we had many telephone numbers, so whenever they would block it, yeah, whenever they would block a phone number or a block of phone numbers, we would just recycle and use new ones.
You are the European Parliament's worst nightmare. I love it.
That's the best compliment that I've received in a long time. More questions?
Yeah, I want to.
Please, Tim.
So I think I am in sympathy to everything that you're saying, or I agree with you on most of the things, but I find content moderation the hardest questions.
Yeah.
And I wonder, it wasn't clear to me what your view is exactly on content moderation. And I wonder if you could, maybe we could even just talk about what,
Yeah, I mean,
more about that, because I think that's hard.
yeah, it is. That's also why I am working on it, because the other stuff is boring. And platform regulation is the only intellectually challenging thing. And so I've written all of that down on platformregulation.eu,
Okay.
and I'm happy to talk about it. So,
Well, why don't we talk about it now a little bit since we're here?
good. So the basic idea is that you have those two buckets. You have illegal content and then you have harmful content. They should be treated totally separately. Because for legal stuff, we have courts, we have a legal system. So ultimately the decision about the illegality of content needs to lie with the courts.
Right.
And you have to get the incentive right so that the platform cannot just start deleting stuff and get out of liability there. Whenever you try to enforce these rules with liability, you end up with an incentive for overblocking.
Right.
Ultimately, the right way to think about it for us, and we already written that down when we were contracted by Greenpeace in 2017, is that the incentive needs to be, the platform of course has to decide first, but whenever there is an appeal, both from the person that notified or the person that posted, that appeal needs to go to the court, and we also need to update the legal system.
Which court?
The national court. In EU, that needs to be a national matter because we've actually not harmonized freedom of expression law. Defamation has been abolished in the Nordic countries, but strengthened in Spain.
Well,
So,
in Iceland,
yeah.
my boyfriend got, accused, deemed in the Supreme Court for defamation.
I'm speaking like it was Finland and Norway that abolished it.
So I just want to understand your position clearly. So you think the general, let's talk like one platform, take Facebook.
So, it's important to make, like the problem of the copyright debate was, we try to regulate Google or YouTube, and we end up shooting at YouTube with a shotgun, but killing half of the internet.
Okay.
So we need to rules that are proportionate. Proportionate means the highest responsibility needs to lie with the biggest platforms. And the lowest entry barrier should be so low that it can be fulfilled by even the smallest possible startup, which means notice and takedown. That's ultimately where you end up if you're really small. But the higher you are, the better your procedures need to be. To answer your previous question, so for illegal content, a court should decide. If the court decides differently than the platform, and the platform has also done a mistake, it wasn't like new evidence came up in court, then the platform needs to pay a fine. The positive thing about that model is it also worked if the content decision is done by an algorithm, because that's training. For legal harmful content, we would take a very soft touch approach, because we think that if a government decides to keep something legal, then of course terms of services could still prohibit it. You can delete all cat pictures if you have a social network for dogs. Yeah? But we need at least transparency about those rules, about the individual decisions, procedural safeguards. For example, notifications and counter notifications. Those things should apply for bigger platforms, even for legal content. And then, as an oversight body, we would see something like the Social Media Council, but not the Facebook version, really a global multilateral body that really can also act as an appeals body for these content moderation decisions about legal content.
So how would you feel about a big platform that decides, we just really don't like hate speech at all, and we think, any thing that speaks badly of a group, it should be taken down. You think that's fine for them to, that's what we're going to do?
So I think that our governments make rules. For example, in my country, it's illegal to deny the Holocaust. Those rules need to be accepted. But in everything that's left legal, but where you say, okay, but my social network, my company, my platform for discourse, has these rules, as long as they are transparent and people know what they get into, I think that's totally fine, that you have these different types of standards. When it's really dominant platforms, of course, then we enter into a new phase. And for example, there is a court case from Poland against Facebook if fundamental rights actually apply to a company as big as Facebook. So that's a very interesting avenue to explore, because that also leads to ideas of must carry for Facebook and stuff like that. But then it gets really tricky. Asta, you wanted to say something?
No, you answered the question.
Okay.
So you, basically, if I get it right, you definitely want governments to be very involved. You don't want the, I mean, you had that Kermit the Frog thing. But you basically want it to be governments being very involved in deciding what is harmful speech and not, or legal, not legal speech. You
So-
want the government fundamentally to have a big role in that.
I think that's also a big difference between the US. The people working on platform regulation there mostly think we actually need to improve the terms of services. In Europe, that's, I think, not the consensus way. We actually want to have laws that limit the power that these corporations have. And we don't trust them, I think rightfully so, given the record, that they will come to the right decision. But again, ultimately, it's about the incentive structure. Right now, overblocking is the cheapest way to get out of the problem. More questions? I also see we have a microphone.
Yeah, thank you very much, Thomas Lohninger. This was great. We have to get on with the shadow because we also want to hear about the other projects and people who want to speak here. And if you have more questions, ask them after the presentations. And now I would suggest we have a 5-minute breaks, and then we start with Snow Haze presentation, the safe browser for iOS.